Okay, before we get into today's exciting topic, I do love today's topic, I want to say some things about the midterm. First of all, the issue of all the disruption happening because of the there not being enough exams. I'm still not sure how I want to handle that situation, and so I hope you will indulge me with giving me more time to think about it. I have recommended to the GSIs that they grade the exams exactly as they are, without any extra points given to anyone. And that might be the end-up default that I decide to go with, but I'm not happy with that. I'm also not happy, I definitely do not want to give extra points to some people because there's no way to determine how many extra points should be given or who they should go to even. There was one student who made 96 on the exam and was one of the students who got the exam late. So that person apparently wasn't disadvantaged too much. But every person's issue is individual, obviously, and I want a solution that is as fair as I can come up with. Also, I have thought about the option of giving another midterm and scrapping this one. However, I do not like that solution. I'm just throwing out ideas. I do not like that solution particularly because two reasons. One, those who studied well, studied a lot, and did well on this exam, it would be unfair for them to have to take another exam where they might not do as well. Secondly, it does take away lecture time. And the primary purpose of the course is not the evaluation, but the learning material. So if any of you have suggestions, please email them to me. I'm open to hearing anything that any of you say. Please do so. If you have creative ideas, that's great. So that about the disruption. About the exam itself, I actually thought the exam was good. I asked our Zhao Yu, our head GSI, to make an exam that had a median of around 60. I like to have medians that are relatively low compared to what you might have generally had, because I really do not like exams that have a lot of people squashed up at the top. As it is, we had a scattering of people in the 90s, but not a tremendous number, and that's good because I don't want there to be 1 or 2 points that differentiate who gets an A and who gets an A minus, or who gets an A minus and who gets a B plus. So I like there to be a large distribution, a wide spread at the top. The bottom actually isn't so relevant. I mean, a C is a C, who cares? It's really the high end. Also, many of the questions, as you now know, were on material that built on what you learned, but was nothing that you had seen before. This was intentional. I'm not interested in whether you can give back the information we've given or redo an example that you've already done. What we're trying to do here is build an understanding of how to use these materials in a new way. When you come across a new problem, what do you bring to bear on it? And so that is the core thing that I'm concerned about. Doing all the exercises that you did up to this point makes your mind more facile and more agile at addressing new issues. And so that aspect of the exam was intentional, and you should expect it on the next ones also. You've probably heard, this is what I think education is all about, is learning how to solve new problems when they come up. I'm sure you've all heard about the diverging income distribution in the United States. Some groups getting poorer and those getting richer. The group that is getting richer are the people who are well trained and know how to address new problems. The returns to education have been rising every year. The value of a college degree and a graduate degree have been increasing, the extra income you can get because of having that degree. And it's not just because of the topics that you learn. It's because of the mental exercise you go through. It's like going to the gym, you know, pumping up your body. This is pumping up your mind. This is, I think, going to become an even bigger issue as we move forward with outsourcing of jobs. Jobs that anyone can do, they're going to get outsourced to India and China. You need to be, each of you are capable of being, and you want to be, on the side where no one else can do the kind of job you do, that you have skills that are exceedingly strong. This is one thing that the United States still has preeminence in. Our higher education system, at least the better part of the higher education system, is unlike any in the world. So we still can have a competitive advantage, but it's through a lifelong dedication to not just learning things, but learning how to adapt to new situations and apply your ideas. Anyway, so as a pep talk, if you want to get rich, then this is the way to think about it, how to use these ideas in new settings. Okay, so before we go on, anything you want to say here, you can email me too, so please do. No? Great. Thank you. Okay, we talked last time about regulation of natural monopoly. When you have a natural monopoly and you don't want it to price like a monopolist, what do you do? Today what we want to talk about is what if you don't want to have monopolies? That we have a situation where it's possible to be competitive, but we don't want there to be the growth of monopoly power. We have set up in our society a set of laws that engender competition and prevent, in certain circumstances, the growth of monopoly power. And that's what we're going to talk about today. The first one's the Sherman Act, and the second one's the Clayton Act. These are the two most important ones. We have a whole set of laws, and in fact, each state has their own laws, but these are the primary ones. And the two, as you're going to see, interact with each other. They're very complementary. Some cases are better to be brought under the Sherman Act, some under the Clayton Act, and they operate in slightly different ways. So I want to describe what they are, what is illegal under them, and how they are adjudicated. So first, the Sherman Act. Sherman Act was passed in 1890 by Congress. It was in a period where there was a tremendous increase in what were at that time called trusts, companies combining together and becoming large and monopolizing industries. And Congress reacted to it by passing this law that said, its key phrase was, every person who shall monopolize or attempt to monopolize or conspire to monopolize, so it's not just succeeding, it's attempting, shall be deemed guilty. The original legislation actually had of a misdemeanor. It's been changed since then and made more serious, and it is exceedingly serious. Companies can be broken up, find tremendous amounts of money, all kinds of things happen. Okay, so the basic question here is, what does this law outlaw? What does it mean to be monopolized, to monopolize? Two things are extremely important to recognize, and both of them are things that if you're going into law, you would probably recognize already. First of all, monopolize is a verb. It's not a noun. It is not illegal to be a monopoly. And in fact, one of the first cases that was tried, the court actually wrote in the opinion, though it was probably not needed, that mere size is not an offense. Being a large company, having a large market share is not in itself illegal. Why is this? The reason is, for all law, just as a concept of law, it cannot be illegal to be something. Status is never a basis for legality. Only doing something can be illegal. So it's not possible that being a monopoly can be illegal. That's a status, and that's outside of our concept of jurisprudence. It's only doing something. That's why Congress used a verb instead of a noun. I think, though I've never bothered to look this up, someone should maybe look this up in the Oxford Dictionary. I think monopolize as a verb had not been used before Congress used it. So they specifically made a verb for the purpose of the legislation. So it is doing something, but what is it that is being done that is illegal? It's not being a... And probably the best summary of it is what I've written down here. Just acts whose purpose or intent is to gain, maintain monopoly power, exclude others. That's what's illegal. The key concept here is purpose or intent. This is another concept that is prevalent throughout our criminal justice system. A person doing something is not in violation of the law if they didn't intend to do it. This is the basis for the insanity defense on murder. The person had no mental capability of having intent, and so they're not guilty of murder. They're guilty of another crime that does not involve intent, or that form of intent. So intent is always an issue within the legal system, intent to do the action. And in particular with the Sherman Act, it is essentially the key element. The courts look to whether the actions of the firm suggest an intent to prevent other firms from competing with them successfully. So the archetypal way to look at this is that a firm that goes out, makes a good product at a good price, and gains a monopoly as a result of it, they did nothing wrong. That's not illegal. But as soon as the firm does something where they're trying to exclude their competitors, prevent their competitors from somehow competing with them, then that's in violation of the law. Those concepts are even today exceedingly difficult to distinguish. When does just creating your product and putting it out there versus doing things to hurt your competitors, because putting out a good product does hurt your competitors, they don't get as much demand. So what I want to do is go through a set of 3 cases that kind of hone in on what exactly is meant here. These are very famous cases. Standard Oil was one of the earliest cases that was brought. The Rockefeller brothers established a little history on this, Standard Oil, in 1870. Today they're looked at it as pillars of society. The Rockefeller family is, very distinguished. Back then they were evil hombres. They, in the course of 20 years, at the time that they opened their company, there were thousands of small oil companies all around the United States. They mostly sold kerosene. And what happened was the Rockefeller brothers went in, would generally go into an area, price discriminate to reduce the price in that area for their product. That would cause the other company to go out of business. They would then buy up the other company. They also bought up the railroad rights for the transportation of kerosene, and then refused to allow the competitors to use the railroad or charge them such exorbitant rates that they couldn't sell at a competitive price. There was even evidence brought to bear, though the court did not decide on whether this actually happened, that there was espionage, that companies that would not sell to the Rockefeller brothers at the price that the brothers had suggested, somehow their plant blew up. So over this 20-year period, they went from a small company, only one of thousands, to having 90% market share. And the case was brought against them. It was a long case, and it was a very interesting case, but the decision, I think, was this was exactly the kind of action that the Congress was intending to prevent. And so the court found them guilty. It's interesting what the court said, though. And listening to the wording really tells you how to think about this. What the court said was the intent and purpose to exclude others was frequently manifest in acts and dealings wholly inconsistent with the development of business power by usual means. So they were setting apart the idea of actions that are development of business power by usual methods versus acts and dealings that showed an intent to exclude others. So then that was where the court first set up this standard, that there was a need for intent to exclude others, to make illegality. The question then becomes, where does this stop? I mean, in a sense, when you're creating a product, you're always wanting to exclude your competitors. You're always wanting to beat them out. That's the essence of competition. So where does this dividing line, where does this intent to exclude others versus creating a good product fall? Next case that is interesting here was kind of setting up what the opposite side of this was. Eastman Kodak. Eastman Kodak developed a new way to do photography, and as a result of that gained market power quite quickly. They practically controlled the market within a few years. In the sense of growth of monopoly power, it was very similar to Standard Oil. However, there was no evidence in the record that was brought to bear that Eastman Kodak had done anything to try to exclude other companies from providing photographic material. The court found Eastman Kodak not guilty and said this is the type of a monopoly that can be considered simply the result of good business practice, not trying to exclude others. So those are two extremes. One that's kind of in the middle, the dividing line, is Alcoa. Alcoa was set up in 1888, and it had a patent on the creation of aluminum through 1909. In 1909, the patent, so for that period, it had a monopoly, but it was protected by a patent, so it was a government-given monopoly. There's no way it could have been illegal. However, starting in 1909, its patent expired, and it continued to have a monopoly through 1940 when the case was first brought. No other firms entered the industry throughout this whole time. So then now the question becomes, how did it maintain its monopoly power? Was it doing things to prevent other firms from entering, or was it just, nobody wanted to enter? That was the basic question. The evidence hinged on one particular action that Alcoa was involved in. They bought up the bauxite ore mines whenever they became available, whenever they were discovered. Bauxite ore is used to create aluminum, and so what Alcoa was doing, it created aluminum. As part of its process, it needed the ore, and it bought the bauxite ore mines whenever they were discovered. This could be seen as prudent business practice. If you're creating aluminum for the world, you need to have the ore to do it, and it's cheaper to buy the ore, the bauxite mines, than to buy it from the owners of the bauxite mines, because then you don't have the intermediary involved. And so that's a prudent business practice. You're just creating your product, getting your inputs as necessary. On the other hand, what the effect of it was, and perhaps the intent, of course, you never can observe intent. Intent is in a person's mind, so you can't ever observe it. You have to infer it from things. It did have the effect of preventing any other firm from entering because no other firm could get bauxite ore. Alcoa was the only company that owned the bauxite ore factory mines. So the question was, is this illegal monopolization or is it not? What do you think? How many of you think that they are guilty? How many think that they're not guilty? How many think they should just be thrown out in the street anyway? Well, the court found that they were guilty. However, I doubt if this case were tried today, the same decision would be made. I think this was this is definitely the dividing line between what's legal and what's not legal. And I think it probably, by most views today, is a little bit on the side of going too far on making things illegal. What the court said, it's interesting, is that Alcoa did not need to double and redouble its capacity. Alcoa meant to keep and did keep complete and exclusive hold on the ingot, the input market. Okay. So the court inferred intent from the buying up of all these ore mines. And I think what might have been going on in the court's head at that point was that they didn't actually need all that ore at that moment. They so the purpose for buying it would have been to keep competitors out. It's hard to know. Also, this was decided by I love the guy's name. His name was Learned Hand, Justice Learned Hand. It was a lower court. It was not appealed up to the higher court, and so there was no Supreme Court ruling on whether this would hold. But I think it points out the difficulty in this line of law, of trying to figure out where exactly is a firm overstepped the bounds of good business practice. Okay, recently there have been very few cases actually settled in court. We've had 3 major cases over the last 20 years. None of them were decided. And part of that is because it's relatively clear what's illegal. The extremes are very clear. What's legal is pretty clear. What's illegal is pretty clear. And the inside fuzzy line, you know, everyone's afraid to go to court because you have no idea how it's going to decide. Okay? The 3 cases that have come up recently, I want to quickly describe. One of them is AT&T, the first one. You've probably heard about this. AT&T was accused of monopolizing the telecommunication industry under the Sherman Act, and the end result was that there was an agreement between the government and AT&T to stop the suit, and AT&T broke up, sold off all the operating companies and kept the long-distance company. So that was a settlement of the of this case. This looks like This looks like Standard Oil. And Standard Oil, what the court did was, after finding Standard Oil guilty, they broke them into lots of oil companies, and all the oil companies we have today are descendants from the original Standard Oil. So it looked like that. However, it differed in extremely important ways. I should point out, I was hired in AT&T's defense, so truth in advertising here. I worked on their defense in this case. What was peculiar about the case is, recall what I had said last lecture. AT&T was given its monopoly by Congress. How can you illegally gain a monopoly that's given to you by Congress? That was the basic problem that the government had in trying to prove a case against AT&T. What they needed to do to show that AT&T was actually trying to monopolize was to show that AT&T was trying to manipulate the regulatory process. Remember that their prices were also set by regulation, government boards, and so the prices in themselves could not be evidence of intent to monopolize because they were set by government agencies. So the question became simply whether AT&T was trying to manipulate the regulatory agencies in a way that maintained its monopoly power to the exclusion of others. My reading of the case is that the government realized midway through that they weren't going to win this case, and so they settled in a way that was highly advantageous to AT&T. AT&T had been lobbying Congress for years to get rid of the local operating companies. Those were the money-losing operations. They wanted rid of them. They wanted to stick with a high-profit, long-distance market. And so what happened here was, as a result of the consent decree, they were able to do what they had been asking Congress for quite a few years. But it was portrayed in the press as if the government beat up and broke up this large monopoly. I think it's an interesting case because, again, it was a monopoly that was conferred by Congress, so it's kind of strange. Next one was Microsoft. Does anyone remember what the big issue was there? This was in your time. It was the browsers. There was no issue about Microsoft becoming a monopoly within the operating system. That was taken as given as simply a good product with a good price. But what was the problem was whether having a monopoly in the operating system, they were using that monopoly to gain a monopoly in the browsers. At that time, Netscape was the first browser out, and Microsoft made its own browser, and it was exceedingly difficult to use Netscape within the operating company system that Microsoft had. That one went to court. It was decided mainly against Microsoft in the lower court. It was appealed. Major portions of the case were thrown out, and it was pushed back to the lower court, and then it was settled. So again, we have no definitive statement on this. But the settlement was that Microsoft would allow other browsers to be interlocked within the operating system as easily as the Explorer, and would do the same for other applications that have to interact with the operating system. So the fact that, how many of you use Mozilla Firefox? Yeah. Your ability to use that is the result of this case. You probably would not be able to use it very easily or at all if it hadn't been for this settlement of this case. And then the most recent one is Google. Again, Google's monopoly in the search industry, it's near monopoly, is not at question. The only issue there is whether they're using their monopoly in the search engine to give priority in the listing on a search to their own products, which would be attempting to give unfair advantage to their products relative to other firms' products within the search engine. So it'd be a matter of trying to extend their monopoly power on the search engine to their monopoly to create monopolies in other industries, in the applications that are searched for. And that's the question. That hasn't even been been filed, and so it might not be ever filed. But the issue there is not whether the firm is a monopoly, but whether they're doing things with the intent to from which the intent to infer can be whether the intent to exclude others can be inferred from the action. Okay, the problem with the Clayton Act, given the way I've described it, is that you're really looking for intent, and yet intent is not observable, and so you have to infer it from actions. This is extremely difficult. A lot of times we have to admit that firms are intending to exclude others and getting away with it because there's just simply no way to prove that they're doing it. The Sherman Act is good in that it is very broad, but it's problematic because it's hard to prove anything. The Clayton Act complements that. The Clayton Act was passed in 1914, partly in response to issues that were raised with the Sherman Act. What this act did was to outlaw specific actions by firms, independent of whether there was any intent or not. So the key words was it outlawed specific things. We're going to talk about what, when the effect may be substantially to lessen competition. So if any of these actions were done by the firm and it lessened competition, then it was illegal, whether or not it was intended to lessen competition. So here, instead of having a broad act like the Sherman Act that makes everything illegal that has the intent, okay, here we're having specific acts where intent is irrelevant, just the effect. The specific acts that were outlawed were tying agreements, we're going to talk about each of these, mergers, and price discrimination. So if a firm engages in tying agreements, merges with another firm, or engages in price discrimination in a way that lessens competition, then the firm is found to be in violation of the Clayton Act. If they do other things that lessen competition, that aren't any of these specific acts, then they're not in violation of the Clayton Act. So it's very specific acts if it lessens competitions. And the key element here that differentiates this from the Sherman Act, like I said, is if they lessen competition and that the effect matters, not the intent. So you should be asking yourself, didn't he just tell us that in all jurisprudence, intent is relevant? That's true. I said that. So how is it that the Clayton Act can get away without looking at intent, where our entire judicial system, our criminal justice system, is based on the idea that intent to do the act is a necessary component of illegality? The way they did it was quite wonderful. This is why I think we have such a creative nation. We've thought of ways to deal with these things. What Congress did was set up a commission called the Federal Trade Commission. And the Federal Trade Commission's purpose in life is to oversee the Clayton Act and other things. But one of the when the Clayton Act was set up, it was the purpose was to adjudicate the Clayton Act. And what the commission does is to identify whether a firm has engaged in an action that lessens competition in violation of the Clayton Act. And if it finds that the firm has done that, it will send the firm a notice telling them to cease and desist, quit doing that act. Notice that the Federal Trade Commission, the FTC, is not accusing them of breaking the law. They're not being taken to court for breaking the law. They are simply sent a letter telling them, you have to stop doing this. You have to quit doing the tying agreement, you have to not do the merger, or you have to not engage in this price discrimination, whatever it was that the FTC found was causing a lessening of competition. Then the firm can either abide by what the Federal Trade Commission said or not. If the firm at that point decides to go ahead and continue its action, then the firm is guilty of disobeying a legal order by the Federal Trade Commission. And their intent is exceedingly easy to show, because if you've got the order, it was sent to the firm, and they continue doing the act after they got the order, they must have intended to ignore what the Federal Trade Commission told them to do. So there, they are then charged not with a violation of the Clayton Act, but rather with a violation of the act that led to the letter, but rather with a violation of the law which states that they have to abide by the cease and desist orders from the Federal Trade Commission. The third possibility that the firm can indulge in, it can stop doing what it was told to not do, and then it can appeal into court. And the appeal in that case is arguing to the court that the Federal Trade Commission is overstepping its bounds by placing this cease and desist order. And notice what's happened now. The firm that is the plaintiff, the party that's the plaintiff is the firm in this case, and the Federal Trade Commission becomes the defendant. So the roles have been reversed. The firm, if it wants to not abide by the cease and desist order, has to go to court as a plaintiff and prove to the court that the Federal Trade Commission was overstepping its bounds in making this cease and desist order. That's an exceedingly hard hurdle to overcome. So as a result, most of this is done through negotiations between the Federal Trade Commissions and the firm. Firms, for example, that want to merge will write to the Federal Trade Commission beforehand, ask them whether the merger is okay. The Federal Trade Commission will do an investigation. We'll decide either it is or it's not. We're going to talk about that a bit more in a second. Okay, so the three actions that are found to be illegal: tying contracts. This is when a firm has a monopoly in one industry and uses that monopoly to force customers to buy another one of its products. So if you have to buy one product from the firm, and it says they're only going to sell you that product if you buy another product, that firm is essentially able to use its monopoly in one industry to gain a monopoly in another industry. This is what, under the Sherman Act, Microsoft and Google were being accused of. Under the Clayton Act, they could also be accused. One of the first cases that was brought up was IBM machines. And IBM sold machines. This was back in the early days when we had these huge mainframe computers. And you fed cards into them, the punched cards. How many of you have seen these punched cards? Yeah, some of you have still seen them. There's old movies that have them. I think there's one with Spencer Tracy and Katharine Hepburn where the machine starts spewing out it. No one remembers that? Anyway, So back there, you had these computer machines, and you read in a stack of cards, and it processed the punches on the cards. IBM required that if you buy their machine, you had to also buy their computer cards to use on their machines. The FTC sent them a letter telling them to cease and desist, that this is a tying agreement that lessens competition in the computer card market. IBM appealed it into court, and their argument was that they needed to assure the quality of the cards because they were responsible for the maintenance of the machines and the reputation of their machines. If people used poor quality cards, they would get jammed, and their IBM would have to send out repair people to fix it, and their reputation as a computer company would be harmed by that. The court was sympathetic to that, and gave an alternative proposal that was in between what the IBM wanted and what the FTC had decided, which was that IBM could set up a set of specifications that all cards had to meet, and then any firm that could meet those specifications would be allowed to sell the computer cards, and other companies that didn't. So they were required to set up specifications that would maintain the quality of their machines and prevent the low quality computer cards from happening. Notice that nothing in here was ever was stated about AT&T being in violation of the law. They were not in violation of the law. They had a cease and desist order. They ceased and desist when they were told to, and they appealed it into court, and the court decided now in the future this is what you have to do. The thing about the Clayton Act that's different from the Sherman Act is you can never punish past behavior because there's never any illegality, any criminal action that's being accused. All that's being said is you've got to stop this. Going forward, you can't do it. And either the firm abides by it, appeals to it, or ignores it, in which case that becomes an issue. Second, another case was automobile manufacturers and car radios. Back in the early days, cars had their radios hardwired in, and that went to court, and aftermarket for all kinds of products that go into automobiles now as a result of this case, where the court decided that the FTC was correct, that the automobile companies cannot require buyers to use the radio and other products that the manufacturer provides, that everyone has the right to buy elsewhere. This has had pretty big effects. Mergers. The issue of merger has changed quite a bit over the last decade. Until the last decade, the rule that I'm giving you here was pretty well followed. If the firms are in the same business and they held more than 12% market share after being combined, then that was considered sufficient to substantially lessen competition. Notice that the word is substantially lessen competition. It does not create a monopoly. So you don't have to be big enough to become a monopoly. You just have to substantially lessen competition. So if the merger had 12% or more, it was considered to be in violation of the law for horizontal mergers. An example of this was Bethlehem Steel and Youngston. The two of them combined. Youngston was relatively small, and yet when it was combined with Bethlehem Steel, it came to over 21%, and that was considered to be sufficient to lessen competition. It's interesting that Bethlehem Steel already had more than the 12%, so under the old reading of this law, it would not be able to merge with anyone because it was already over the threshold. Yeah. Yes, the question was, is it hard to measure what is the market? Yes, I've been involved in several merger cases, and that is the key element. What is the market, and then what is the market share of each firm within that? But after you define what the market is, it's relatively accounting procedure to see what the market share is. So the battle is tremendously over what is the market. I remember when Calistoga wanted to merge with Perrier Water. Steve Goldman here in our department was hired as the consultant for the merging companies on that merger. The FTC defined water as bottled water in glass cans, glass bottles, not including, the plastic bottles. And of course, Perrier and Calistoga had a huge share, and under that ruling, it would have been disallowed. Steve Goldman argued that the market was water. Perrier and Calistoga sell a tiny percent of the water that's sold in America. That's a great example of how extreme it can be, and then, it's a fact issue of what actually is going to be considered the market. The whole issue is, to what extent is there elasticity, cross-elasticity of demand between the products? But yes, that's a big issue. Okay, what often will happen in these cases, several that I've been involved in, the government will come to an agreement with the merging firms in which some of the assets of the merging firm will be sold off to set up competitors. So if two firms want to merge, it's possible that some of the assets will be sold off to create a competitor to those, particularly if there's there was a bread case I was involved in where there was high concentration in certain cities, and so the companies that were merging were required to sell off factories in those cities and create competitors. So often these are more often than not, they're handled through negotiation between the firms and the Federal Trade Commission. But of course, the Federal Trade Commission has the upper hand in these negotiations, since it can always just say, no, you can't do it. And that places a huge burden on the firms to try to prove that they overstepped their bounds. Now, what I said was that this is the policy that until recently has been applied. Recently, there has been much more emphasis in merger litigation on the issue of potential competition. Even if firms aren't currently in the industry, if the firms that were merging happen to raise their prices because of the merger, then if it were to induce new firms to enter, then that would be sufficient competitive pressure against merging firms. So two firms, for example, Bethlehem Steel and Youngston, just to use an example. Under this ruling, they would not be allowed to merge. But under the idea of potential competition, they perhaps would. If those two companies could show that as soon as they raised their price, if they ever tried to raise their price, other firms would enter the industry and defeat their price increase, then the new court rulings are allowing that. So now firms that have more than 12% market share are routinely being allowed to merge, but only under circumstances in which there seems to be sufficient potential competition to protect the public against price increases. So potential competition is seen as part of the issue of the lessening of competition. Potential competition is part of that, which increases the amount of competition. And finally, tying agreement, price discrimination. This somehow didn't show up right. This is a very important case. Morton Salt was selling salt to grocery stores, and the FTC investigated it and told them they had to quit selling at different prices to different grocery stores. It sold to one grocery store at $1.50 a case, and it sold to the other ones at $1.60 a case. So this $1.60 is supposed to be over there. So grocery store one got it for 10 cents less than the other ones. The problem with price discrimination generally is that if a firm sells to a downstream firm at a lower price than it sells to the other downstream firms, that gives the firm that gets the lower price a competitive advantage and allows it to reduce competition, hurt its competitors in that market. In this example, grocery store A would be at a competitive advantage relative to grocery store B and C because Morton Salt is selling the exact same product at a lower price to grocery store A. So that gives them a competitive advantage. Yeah. Good point. Let's return to that in a second. That's a good point. That's part of the decision here. The first thing to note here is the lessening of competition is not occurring at the level of the firm that is doing the the price discrimination. It's not like Morton Salt is defeating its other competitors or eliminating other salt producers. So this is another emphasis, or recognizing this emphasizes the fact that we're not concerned about intent. Morton Salt could care less. It doesn't matter to it how much competition or how much monopoly there is in grocery stores. They would care about their own competition. So here, it's not even possible for Morton Salt to have the intent to monopolize because they don't benefit from it. And yet, it still has the effect of lessening competition in a downstream market. So that's why it was illegal, and that's why the Clayton Act was able to stop it, because it had the effect and intent was not relevant. So again, Morton Salt was never accused of any crime. It was simply told it had to stop doing it. In this case, Morton Salt appealed to the government, to the court, and two arguments it made. One was that the 10 cents difference, given that salt is only one of a multitude of goods that is being produced by an industry, sold by a grocery store, could not possibly affect competition in the grocery store industry. It's not like anyone believes that A is going to get a competitive advantage over B and C because of a 10-cent difference in salt, given that grocery stores sell thousands of items. And what the court did on this was say, that's true for this one item, but if we then apply that for every single item, you would have a lessening of competition. So if the person who sold salt sold A at this price, and the person who sold pepper sold it at a lower price, and the person who sold beef sold it at a lower price, if each of them was acting in accordance with the law, you couldn't prevent the lessening of competition that occurs from all of them happening. So it said the court ruled that the FTC is within its bounds to stop it even in this case. But the question then becomes, how small of a price difference does it have to be? And what the court ruled there, or the standard it set, was to say that the price difference exceeded the profit margin that the firms are earning on the item. And so essentially the 10-cent price difference, the court found that the profit margin on the sale of salt by the grocery store was only about 3 or 4 cents. I can't remember what they did. So 10 cents was higher than the profit margin. What that would mean, the court said, is that grocery store B and C, to match grocery store A's price for salt, would have to actually sell at a loss. And that in itself can be considered to be evidence of lessening of competition. If the only way a store can meet its competitor's price is to lose money and that on that item, and that is caused by price discrimination by an upstream firm, then that is a lessening of competition that's outlawed. Morton Salt also said that they sell in bulk to grocery store A, and that's why the price is lower. The court said that that in itself is not a good reason, but it did set up a standard that if a upstream firm, Morton Salt in this case, sells to different grocery stores and incurs different costs in doing so, then it can sell at a different price in accordance with the costs. So if Morton Salt could show that its bulk pricing reflected a reduced cost of serving that customer, then they could charge the lower price. So that's where the case is now. Now, if firms want to charge different prices to different downstream firms, they need to show that they have a cost justification for doing so. And that's a relatively high standard. One last point. It is also never illegal to price discriminate among consumers. So for final goods, price discrimination is never illegal. Why is that? Somebody answer. Nope. There's no lessening of competition. What's happening here is Morton Salt selling to these grocery stores reduces competition in this industry. When you're selling to customers directly, there is no industry downstream to have a lessening of competition. So price discrimination to ultimate customers cannot be in violation of the Clayton Act. Okay, thank you. Come back Wednesday.